Welcome back to Las channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Let me tell you one of the most ridiculous cases I've read in a while. We have officers that receive a phone call from a concerned neighbor saying that she hears a woman crying, doors are being slammed, and so on. The officers go to the scene and try to check on the woman. They're doing what's called a welfare check. When they get to the door, they knock. A man answers and tells them that everything is fine, and at this point, the house is all quiet. Nevertheless, the officers go inside the house without a warrant, without consent, to check on the woman. When they go into the basement, they find the woman highly intoxicated, but she says that she's fine. She's uninjured, she appears without injuries. The officers ask her whether she's fine, and again, she says that she has no injuries. There was never any physical altercations. And after they check on her, they continue with their weird investigation. They take the man upstairs. They handcuff him. At this point, the man's brother and the owner of the house comes out from his bedroom. They take the brother outside of the house, put him in a squad car, check on his driver's license. And in the meantime, one of the officers sees some glass vials in one of the rooms. Now, these are generic glass vials that you would see, let's say, a contact lens solution or some other items that could be inside. He picks them up, puts them to the light, tries to figure out what's inside them. In the meantime, the man tells the officer that those vials belong to his brother, who's a paramedic, and he's allowed to have those. The officer looks at the labels, checks on the label, takes out his phone, tries to figure out whether any of the things inside are controlled substances. The government later claims that they were allowed to check on the vials and figure out whether those were legal based on community caretaking exception, the welfare check, exigent circumstances. But of course, we have to figure out whether it was actually legal and whether they can actually rely on those exceptions. And before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Dane Arredondo. Now this video is a little bit different because I pretty much gave you all the facts up front in the introduction. But let's do a quick recap. In the late hours, officers are dispatched to Dane's house after a neighbor calls and says that they're hearing a woman screaming and doors being slammed at Dane's residence. When officers arrive, the house is quiet. They knock on the door. Dane's brother David opens the door. Now remember, the house is now quiet, but nevertheless, officers make a decision to enter the house to check on the woman. Now they do this without consent, without any permission from David or Dane. When they get into the house, they go to the basement, they check on the woman, they find her to be extremely intoxicated, but nevertheless unharmed. You would think everything would end here, but instead, Dane and David are taken upstairs. They check on Dane's driver's license, they take him out of the house, and in the meantime, another officer is questioning David, who's handcuffed in the main room of the house. While he's being questioned, an officer notices a few small medicine vials. He takes one of them, takes it to the light, tries to figure out what it is, and in fact asks David what's in the vial. David says that his brother Dane is a paramedic and he's permitted to have those. At this point, the officer then looks at the label, tries to figure out what it says. It says ketamine. And so the officer takes his cell phone and tries to figure out whether Dane is permitted to have these without prescription or whether these are controlled substances. Ultimately, Dane is charged in federal court with healthcare fraud, with possessing controlled substances through fraud, and possession of controlled substances. Now, Dane later says that the evidence has to be suppressed because it was found in violation of his Fourth Amendment rights. He actually wins at the lower court level, but the government appeals. We're now in the circuit court, and the question here, whether the officers were permitted to look at those vials and figure out what was inside of them. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct any search or seizure. Here, they did not have any warrants, so they have to rely on some sort of an exception. The government contends exigent circumstances and the community caretaker function justified the officer's presence upstairs, and a warrantless seizure of the vials was permissible under the plain view exception. But don't get confused about all of these three exceptions: the exigent circumstances, community caretaker, and plain view. Because here's what the court says about these exceptions. While we have reservations about the government's claim that the officers were lawfully present upstairs, the exigent circumstances and the community caretaker function having dissipated and the issue of consent being questionable, it is unnecessary to resolve this issue because the plain view exception does not apply. The plain view exception authorizes an officer to seize an object without a warrant if, number one, the officer lawfully arrived at the location from which he or she views the object. Number two, the object's incriminating character is immediately apparent. And number three, the officer was lawfully right of access to the object itself. So let's break it down a little bit. By the time the officers are upstairs, there's no more exigency, and the welfare check is complete. We know that the woman is fine and is unharmed. So really, there is no justification for the officers to remain in the house. But even if we assume that for some reason they were allowed to be in the house, under the plain view doctrine, when they look at the vials, the incriminating character has to be immediately apparent. And here, the court says by looking at the vials, we couldn't tell anything incriminating about them. In fact, the vials could have had any sort of medication, or essential oils, or maybe contact lens solution, or any other items inside. In fact, these are very common medicine vials that we see daily. We also know that the officer himself was not trained on these vials, and he didn't know what was inside. He had to ask David what was inside the vials. And David gave a pretty good explanation. He said that Dane is a paramedic, and he's permitted to have those. It is only after the officer researched and figured out what was inside that Dane was able to be charged with some crimes. But it was too late by then. By the time the officer takes the vial, the taking on the vial itself is a search and seizure. If you remember the case of Arizona versus Hicks, a Supreme Court case I've discussed on this channel a few years ago, go back, take a look at it. But if you remember the case, this was a case where the officers were inside an apartment, they saw some stereos, and they thought the stereos were stolen. But in order to figure out what they really were, they lifted the stereos to check the serial number. Now, the Supreme Court said that the lifting of the stereos was itself a search and seizure. And without probable cause, without some exception to a warrant, the officers could not do that. Same thing here. Without some exception, the officers cannot simply lift the vials to figure out whether there's some incriminating nature to them. The lifting of the vials itself is a search and seizure. And because there was nothing apparent incriminating about them, the plain view doctrine does not save the government. And so for that reason, the district court was correct. All the items that were seized on that day have to be suppressed and cannot be used against Dane. So the case would be dismissed. If you enjoyed this video if you learn something a little bit more about plain view doctrine, some of these other exceptions, be careful because a lot of them don't apply. And if you like this video, give it a thumbs up, share my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.